One of us. John. This is 231-500-139, State of Utah versus Kouri Richins. Counsel for the state are present. Counsel for defendant are present, as is defendant Kouri Richins. Let me just provide a summary of how we got from yesterday to today. At the close of proceedings yesterday, we had a plan to receive defendant's written response to state's motion to admit redacted exhibits 8-57R through 8-63R as prior consistent statements under Rule of Evidence 801 D1B. After everybody left the courthouse and upon reflection, the court did some additional research regarding the foundational requirements of 801 D1B, issued a ruling requesting additional foundation for admission of those redacted exhibits under that rule. That's docket 1700-1700. And shortly after that, had a WebEx conference on the record with counsel to discuss the court's concerns regarding the foundation requirements for that rule. Following that, the state narrowed its request to seek, as I understand it, Mr. Bloodworth, publishing, not admission, of portions of only two of the proffered exhibits. That would be 5-58R and 8-62R under Rule 106. Is that correct?
Yes, Your Honor.
Okay. After that, counsel, to their credit, engaged in a productive email exchange regarding their positions regarding those redactions. I think we need to discuss those one at a time now. Is that your view, Mr. Bloodworth?
It is, Your Honor.
Ms. Lewis?
Yes, Your Honor.
Okay. It would help me to just go through these one at a time and talk about what's happening here. So let's start with Exhibit 5-58R, which is the transcript of a May 2nd, 2023 interview of Carmen Lauren. And we begin, as I understand it, and I'm going off the $8-58R. Did I misspeak? My apologies. 8-58R. Thank you for the clarification. I want to make sure I'm looking at the right email here. I'm not. My apologies. I need to print the state's response. One moment.
Your Honor, it's probably the 8:05 p.m.
Yes, that's right. So, forgive me, Mr. Bloodworth, in response to the state's highlights in and around page 75, lines 1921, the defendant states, quote, "This completely resolves this proffered section, leaving nothing for the court to decide." But then the state, I think, sees it a little differently. Help me understand here.
Yes, Your Honor. The highlighted, I think for the purpose of this discussion, the highlights are immaterial. The highlights related to the 801 discussion.
Okay.
So in the 805 email last night, the state set forth its view by page and line number of the 106 argument.
Okay, so the state's position is that page 65, line 4 through page 87, line 13 from this should be published under Rule 106.
That's correct. And that section of that statement, that section of the transcript applies to both the first and second paragraphs. It encompasses both of the statements that both of defense's statements that are outlined in paragraphs 1 and 2 of the 805 email.
Understood. And so to the extent when we look at 8-58R, to the extent that between page 65, line 4 and page 87, line 13, there are some sections that are not currently highlighted, is the state's position that those are included in the state's request?
Yes, Your Honor, I think for purpose of this discussion, we can ignore highlighting.
Okay, got it. Let me pause there. Ms. Lewis, take a moment. Take the time you need. Brittany, will you restart that printer for me? Thank you.
I didn't realize we were ignoring the highlights until right now. So,
Well, I think if it helps speed things along, as I understand it, the defendant didn't have any trouble with the highlighted portions. It's now the unhighlighted portions between 65 and 87 that we need to make sure you get an opportunity to respond to.
actually, Your Honor, we had agreed to letting in all of the highlighted portion on page 75 and 76 because that would be what was related to the statement that I elicited on cross. So that's what we had agreed to, which is what we believed the state wanted, because like I said, it wasn't until Mr. Bloodworth just said we were now ignoring highlights. So we agreed to page 75, line 8, starting at line 8, through page 76, ending at line 5, under the rule of completeness, because that completed the discussion around the elicited statement, which is give us the details that will ensure Kouri gets convicted of murder. I think going all the way back and adding in everything does not have to do with that statement. It's a lot of discussion. I mean, it doesn't have anything to do with O'Driscoll's statement that was elicited through Carmen. It's talking about, trying to look at the unhighlighted parts now. I mean, it is talking about that it's about she doesn't know the situation between Eric and Kouri, which wouldn't have anything to do with that. It's about when we're going to meet again. She says, I need to go through whatever I need to go through to figure out. I mean, this doesn't have anything to do with that statement by Detective O'Driscoll. I mean, I agree the stuff right before that and immediately after that that completes that line of question and answers should come in. But for example, on page 67, Detective Maynard says, I'm just saying we're going to need you to settle down and get details and timelines. I mean, that doesn't have anything to do with the statement. And it's also hearsay by Detective Maynard. I mean, I suppose if Mr. Bloodworth wants to question Detective O'Driscoll about some of these other statements, that would be appropriate, but I disagree that all of this comes in under the rule of completeness.
I think we need to be a little bit careful here. It's not Detective O'Driscoll's statements that are subject to the rule of completeness. It is Ms. Lauber's statements that are potentially subject to the rule of completeness. And as I understood the state's
That's true.
position, it was the context provided by Detective O'Driscoll's statement on page 75 combined with Ms. Lauber's response on page 82. And that was, as I understood, from back when Carmen Lauber testified in open court, what the state believed they needed to correct the arc of. Is that fairly stated, Mr. Bloodworth?
It is, Your Honor, and I can provide additional detail to the extent we need it.
If you would just make a record for why the state believes page 65, line 4 through page 87, line 13 is required to explain, qualify, or provide context for Ms. Lauber's testimony, I'd appreciate it.
Your Honor, the necessary context is that Carmen Lauber was agitated about her involvement in Eric Richins' death, and the detectives were trying to settle her down and focus her in on the details. The court can see the word details in this portion of the transcript appears a dozen or so times as Carmen Lauber is scattered. They're focused. They're trying to just get her focused in on the details, and in the details, and explaining to her, right? Because the broader context here is they're talking about her immunity, and they're explaining to her that details are necessary so that they can corroborate them, and that corroboration of those details is necessary for immunity. That is the context of the statement.
Ms. Lewis, go from there, please.
Sorry, just a moment.
Your Honor, if the state could add, that is the narrowly tailored context of the statement. The state, water under the bridge, but the state has argued the entire series of interviews provides that context as well.
That's been preserved.
It has. I appreciate that.
Well, I understand what they're saying. I don't disagree that all of that is necessary under the rule of completeness. So I would just stand by our objection that really what should come in is the complete statement on page 75 and 76. I will say, in looking at this though, I was already, when we were looking at it previously, just the highlighted, I really didn't have a problem with through line on page 82 through line 17 on page 82, because I actually do think some of that came in during cross. I'm not, probably like to take out the stuff between, well, no, that's okay, never mind. So I really don't have a problem with line 8, starting with line 8 on 75 through line 17. Although, I'm sorry, Your Honor, this skips. I mean, we go from 76 to 82. So
No, with the state's request, and I can appreciate why you just need a moment to walk through it. But sitting here this morning, the state's request under Rule 106 is to publish, among other portions, page 65, line 4 through page 87, line 13 of
so
this.
you also want, which you didn't include, 77 through. That's where you've lost me.
So there's a gap in what we're looking at, pages 77 through 82.
Is there?
Yes. What they've provided that they wanted jumped from page 76 to 82.
I'm so sorry, Mr. Bloodworth. I'm reading your email of 8:05 p.m. 65, line 4 through 87, 13 inclusive?
Correct.
Okay.
That is correct. I think that the disconnect here is the pages we're looking at. or
Jump.
She's looking at jump, yes.
Oh, okay.
So now you want the pages you don't have your own.
I did not appreciate that. I've got to see the other pages.
So do I.
Yeah, my
Well,
apologies.
I think, here's what we'll do. Page 65, line 4, through page 87, line 13.
7? 13?
Minus pages 77 through 81.
Gotta look at-
Okay. So now we're back to
We're
the
back.
proposed
This will take us here
5-58R.
just in a more efficient way.
Yeah, that's fine. Okay, so Ms. Lewis, my apologies. Now I think we're all on the same page regarding the paper version of 5. I keep doing that. 8-58R that we're looking at. Thank you for raising that. So just so the record is clear, we're currently contemplating page 65, line 4 through 7625, and then 82.1 through 87.13.
I would agree with 76, starting at line 8, through the bottom, I'm sorry, 75, starting at line 8, through the bottom of 76. And I am all right with page 82 through line 17, but we would object to the rest.
Okay, bear with me. All right, so the court is persuaded that the statements of Carmen Lauber elicited on cross-examination, as indicated on proposed exhibit 8-58R on pages 75, line 19 through 22, 82 lines 8 through 11, and page 86, line 17 through 19, require, under Rule 106, context, qualification, and explanation in the form of additional portions of 8-58R. And those additional portions are page 65, line 4 through page 76, line 25, and page 82, line 1 through page 87, 13. clarification, Mr. Bloodworth?
No, Your Honor.
Okay. Ms. Lewis?
No.
All right.
No.
So I think that handles bulleted or numbered paragraphs 1 and 2 in the email exchange between counsel, correct, Mr. Bloodworth?
Yes, sir.
Okay. That brings us to numbered paragraph number 3. Bear with me. So here, to provide additional context, qualification, and explanation for Ms. Lauber's statement that I get that related to the get out of jail free card, Mr. Bloodworth, I understand the state is requesting publishing 114 line 6 through 115 line 6. Is that right?
Correct, Your Honor.
Okay. Ms. Lewis, go ahead.
Your Honor, I think the discussion about what Ms. Richins is doing, about the children and the relationship with their father, all of that doesn't add any context to what Detective Maynard's statement is. I mean, I guess I'm not opposed to going through line 12 where she says, "Oh, I get that," but the rest of it it's also quite prejudicial.
Why is it prejudicial? I mean,
Well-
it doesn't matter if it's prejudicial. I don't have any discretion here if it's required for.
I understand. But-
So
I mean, the fact that he says you're on what your get out of jail free card looks like based on the information that, and then he says there's 3 little boys that don't have a dad, there's a family that doesn't have a brother. I mean, what does her response about the boys and Eric have anything to do with the fact that she now has a get out of jail free card if she gives them her information? It's
I
not
understand the
connected.
state's position to be this shows what her motivation, the complete version of her motivation, rather than just a motivation to serve her own interests. Is that about right, Mr. Bloodworth?
That is, Your Honor. And Detective Maynard couples the two in his statement. It's get out of jail free card looks like, based on the information, that there's 3 little boys that don't have a dad. He's coupled them.
I'm sorry, can you finish?
Yeah.
I don't know why just going through line 12 where Ms. Lauber says, "Oh, I get that." Why doesn't that complete that she gets that that's why it is because of this reason? Why do we have to go into the rest of the relationship with Eric and the kids and that Kouri's living her life while everybody else is suffering? I don't understand how that completes anything more than just ending with Ms. Lauber's statement at line 12, that she understands that's why it is, because of the circumstances.
Mr. Bloodworth? Go ahead, sir.
Your Honor, it completes Carmen Lauber's expression of her motivation to cooperate.
Okay. Having considered the arguments of counsel and looked at Carmen Lauber's statement on page 114, line 12, the court is persuaded that under Rule 106, publishing of page 114, line 6 through page 115, line 6 is necessary to explain, qualify, and provide context for her response. All right. That brings us to pages 182 and 183, correct, counsel?
Yes, sir.
Okay. So here, the statement that the state seeks to provide additional context, explanation, and qualification for is Ms. Lauber's statement on page 183, line 5. Can you guys just write it and I sign it? Correct, Mr. Bloodworth?
Correct, Your Honor.
And the state's position is that under Rule 106, we're required to go back to 182, line 12, and include through 183, line 14. Do I have your position correct?
You do, Your Honor. And that necessary context is that the detectives needed Carmen Lauber to put her verbal statements on paper and that detectives were not able to do it for her.
Actually, I'm fine with that. I think there was a typo in what we said in our response.
Okay, very good. The
Those
court
are
is,
the lines.
oh, I'm sorry to cut you off, Ms. Lewis, go ahead.
No, I'm sorry. I was just saying in terms of the lines we agreed to, I think that's just typed incorrectly. That's not a problem.
Okay, under Rule 106, the state is permitted to publish line 182, pardon me, page 182, line 12 through 183, line 14 from 8-58R. Anything else from 8-58R, Mr. Bloodworth?
No, Your Honor.
Okay. Ms. Lewis?
No.
All right. That brings us to 8-62R, correct?
Yes, sir.
All right. We go to page 12. Here, in response to a question from Detective Maynard, the goal is to convict Kouri for an aggravated murder. These parallel drugs investigations, those aren't a priority. Ms. Lauber says, right. And the state asserts that completeness requires that we also publish page 11, line 20 through page 13, line 22, correct?
Correct, Your Honor. And the necessary context there is that Carmen Lauber is spooked by the federal grand jury investigation, and Detective Maynard is assuring her that that federal grand jury investigation is secondary to the murder investigation.
Ms. Lewis.
Your Honor, I really think that if we start at page 11, line 20, and go through 12, line 20, that it states enough to cover all of that without getting into the grand jury, which is a whole other can of worms.
Why can't we go to 13, line 7? It gets a little confusing after that, I'll grant you, but 13, line 7, I think, is an important closure on that issue of the potential for federal charges.
I'd like to take out the reference to the grand jury. What if we,
Help me understand, what is it you think is a problem with the grand jury? This is what they're talking about, is federal charges.
well, they are, but it's clear in here that she's saying federal charges are the next, that's more up the chain serious, like the highest extreme. So it's already in here that they're already saying that federal charges are more serious, and he's telling her not to worry about that without getting into the grand jury, which causes me concerns. It's I mean, that's something we've avoided talking about. It speculates that it's going to allow the jury to speculate about what that means if there's other charges. I think most people don't know what a grand jury is. They may think there's another jury that's made some kind of finding. I mean, we maybe could go through line 7 if we just take out We could even just take out on 13, starting at line 2, just take out that's where it's formalizing it with the grand jury.
Let's talk about mechanics for a second, Mr. Bloodworth. I understand, or I appreciate that these are many fewer pages of transcript than was under contemplation yesterday. Are we just going to show the transcript to the jury at this point, or have we cut the video down?
Your Honor, we've set the conditions where we can cut the video down. There's still a little bit of editing time, but not much.
Sure.
The state intends to publish by, as we've published other similar exhibits, playing the video with the transcript rolling beneath it.
Okay. All right. I appreciate that. Okay. Mr. Bloodworth, talk to me. Why in the state's view do we need to go beyond line 7 on page 13?
I'm sorry to interrupt, but I'm actually okay if we go through line 10.
Okay. Line
If
10
that
on page
completes the
13.
thought.
That's agreeable, Your Honor.
All right. So, first, the court is persuaded that with respect to state's proposed exhibit 8-62R, publishing page 11, line 20, through page 13, line 10, is necessary under Rule 106 to provide additional context for Ms. Lauber's response to Detective Maynard's question as depicted on page 12, lines 2 through 6. Court is not persuaded that a stray reference to Carmen Lauber appearing before a grand jury will mislead or confuse the jury in any way about any consequences or any investigation regarding Kouri Richins. The defendant's request for redaction of that sentence is respectfully denied. Anything further on that, Mr. Bloodworth?
No, Your Honor.
Ms. Lewis?
No, Your Honor.
Okay. Scott, do you need any of those numbers again?
No, Your Honor, I was following along and I have them down, and I can, provide a copy of the videos as soon as I have them ready to defend, to have the process you would like.
Perfect. I like that plan. Let me just write this one down. Mr. Bloodworth, that means the remainder of state's motion to admit redacted exhibits 8-57R through 8-63R is moot at the current time. Is that correct?
That is correct, Your Honor.
Okay. Got it. Okay. Council, last evening I sent out notice of the court's decision denying defendant's motion for mistrial. I'll issue a written ruling providing the court's analysis in the due course, but I needed to make sure that you had notice of that decision. I also gave notice of the court's designing a remedy under Rule 16 of requiring the state to recall Ms. Lauber in its case in chief to make sure that defendant has an opportunity to cross-examine Ms. Lauber about the alleged violation of her drug court probation in November 2023. I know only 12 hours have transpired since that time, Mr. Bloodworth, but what is the state's expectation?
Your Honor, she will be here at 1 o'clock.
All right. Are we starting with her?
Yes, sir.
Okay. Ms. Lewis, anything further on that?
I imagine that nobody will be discussing with her what she's coming back to testify regarding between.
Well, I told her she was still subject to the subpoena, that she was not released. I'm sure all officers of the court will abide by the rules there. You'd be within your rights to ask her if she's talked to anybody in
Sure.
the meantime.
Sure.
I imagine the state will have some limited redirect of her upon putting her on the stand.
Yes, Your Honor. Maybe we can clarify just scope
Sure.
of cross. I think the record's clear in the state's papers that defense has already had an opportunity to examine her on this issue. I appreciate the prophylactic nature of the court's ruling.
Right.
I'm happy to protect the record. But as I understand it, the scope of defense's cross-examination of Ms. Lauber today is limited to impeachment based on the materials surrounding her supervision.
Yeah, even I think more specifically, the material received by the defense pursuant to the subpoena that allegedly revealed this potential violation of her drug court probation in November of 2023. That's the new information.
Okay, and as I understand, that new information is an unsigned affidavit, although substantively that affidavit is no different than the information provided pre-trial.
Yeah, that was a little unclear from the papers as to whether the subpoena response gave more detail than what was provided pre-trial. I honestly don't know.
Yeah.
And I want to be clear, this will come out in the court's oral ruling.
Sure.
The
Yeah.
court is not making any finding that the Summit County Attorney's Office intentionally withheld any information, but the knowledge of Detective Maynard is imputed to the state. And so we are where we are.
Yeah, and I appreciate all that. I think the only information in the subpoena return that was new was a printout of a link to a drug test result, the link which has long expired. So,
Was the unsigned declaration provided prior to trial?
Your Honor, it was not, but all the substance
I
in
see.
that unsigned declaration was provided prior to
Okay.
trial.
Well, to prevent any
Sure.
infirmity on appeal, my view is that the scope of this recross that the court is providing the defense an opportunity to do are the facts and circumstances related to any potential violation of Ms. Lauber's drug court terms and conditions in November of 2023.
Understand.
Ms. Lewis.
Just some clarification. Well, first, the only information we had before was that she apparently had drank alcohol. The information about the circumstances surrounding that is new. But the other thing, so I included in what the state sent us was the letter that Carmen Lauber sent to Judge Mabee, which I did have before, but I didn't question her about it. But now I would like to point out that what she says in that letter is not accurate.
What's the date of the letter?
February 15th of 2024, where she says that she's been in 100% full compliance. Well, now we know that she's not been in 100% full compliance. So
I don't know if we know that. We know that she was observed holding an alcoholic drink. We don't know if she ever consumed it. And so, I mean, I suppose if you want to ask her if she violated the air condition of not possessing or purchasing alcohol, you can ask her that. But,
Your Honor, I'm not sure that's,
now it says she was consuming it here.
well, that's an unsigned affidavit. We got to be careful. That's not evidence of anything. It's just words on a piece of paper. You can ask her about it, but we can't admit that. Go ahead, Mr. Blood.
Your Honor, the letter to Judge Mabee, I believe, has been in discovery for years.
No, and Ms. Lewis is not suggesting otherwise. It's just she's not suggesting now she has, in her view, evidence that the statements made by Ms. Lauber in the letter are not true. And so she now has a reason to ask her about that.
Understand.
And then we were provided also this I guess it's a screenshot of text between Ms. Lauber and Detective Maynard that we just got also for the first time that I didn't have. So I would like to ask her again about her communications and her supervision.
As long as you're within the dates of those text messages. Unless they had those as well. I don't know.
I mean,
Your Honor, they don't, but she testified to exactly what the text messages show. So I don't know if there's any impeachment there.
And is that true?
She testified that, off of my memory,
Yeah.
she testified that her check-ins with Detective Maynard amounted to one of them texting Lauber, the other responding with Maynard, which is precisely what the texts show. So in fact, I think the text messages are 100% entirely consistent with Carmen Lauber's testimony.
Ms. Lewis, let me look at the text with you for a moment. My apologies.
that's fine. I would need to look at that portion of the testimony again, because maybe my recollection is incorrect, but I know she also testified about a lot of communications with Detective Maynard. I mean, I think it would be appropriate to ask her if these communications were in text, because the texts don't include that. And I don't know why we have just a screenshot of a week of text. I mean, this is incomplete.
Well, but Ms. Lauber's not going to know why that's what you received from the subpoena response. You can ask Detective Maynard about that if you want to call him.
About why we only have these dates. Is that what you're talking about?
Right. Ms. Lauber won't know why Detective Maynard or the Summit County Sheriff's Office did or didn't
right.
produce
I wasn't
additional
gonna-
records.
I wasn't going to ask her that. I was talking about if this is a fair representation of all of her texts. I mean, I was
All of her texts for Saturday, February 14 through Monday, February 16.
Well, I think I could ask her if this was a representation of her text throughout her supervision, if this is what they did.
There's no. What's the foundation for the fact that they only texted for 3 days in February of 2024?
No, what I'm saying is, I think I can ask her, show her this and say, are these 3 days a representation? Is this how you always communicated with him? Not just these 3 days. Does this represent how you always communicated with him?
I'll give you a limited latitude there.
Okay. And then,
I want to make sure you heard the word limited when I said that.
and then I need to look at exactly what she said about that before, but I may have some other questions regarding how they communicated other than these texts.
Take a look at it. Let me know if you want to readdress this prior to 1 p.m.
All right. Let me just make sure that's everything.
Now, to be clear, my view is that because we're in the state's case in chief, when we're recalling one of the state's witnesses, Mr. Bloodworth, if you want on direct to direct examine Ms. Lauber regarding the November 2023 events, if any, you're permitted to do so.
Yes, sir.
Okay.
All right, I think that's it.
Okay. Let me pause there. Anything else on the record at this time, Mr. Bloodworth?
No, Your Honor.
Am I correct that the state's intention, as we sit here at the moment, is to call Ms. Lauber and Detective O'Driscoll today?
Correct.
Do you have any intention, as you sit here at the moment, to call any other witnesses in the state's case in chief?
No, sir.
Okay. Understanding we may or may not get Detective O'Driscoll done today, but certainly will sometime tomorrow. Does the defense, if it plans to put on witnesses, that's your prerogative to choose whether or not to do so, have a couple or more in the wings for tomorrow?
We do.
Okay, very good. Anything else on the record right now, Mr. Bloodworth?
No, Your Honor.
Ms.
Def-
Nestor?
Definitely want to need to take a break after they rest to do our Rule 17 motion.
Fine.
And we also, while we're talking about scheduling, we've got plenty of time here. we would like to build in a little bit of time to have a conversation with our client upon their arresting. There are some decisions the client will need to make. And we may need about 30 minutes to do that.
No problem. No problem. Okay. Anything else on the record at this time, Ms. Nestor?
No, sir.
All right, folks, we will be in recess. Why don't we plan council to be back at 12:45, just to make sure we handle any issues that may come up between now and 1 p.m. All right, we'll be in recess until 12:45. Thank you.
Thank you.
All rise.
Court's in recess, folks.